All right. Well, good morning, everybody. This is Matt Rocco and Caitlin Santonzi from South Florida Manufacturers Association. Thank you for taking the time to join us on a really important and timely topic. First and foremost, we hope you and your families and employees continue to remain safe. And anything that you need from us at the SFMA, please don't hesitate to reach out to myself, Caitlin, any of our business advisors, Jay Hess or Micah Doherty. This topic, I think, is really important. I'm sure many of you all on the call today deal with a customer in one form or another. Could be a vendor, could be in your supply chain, could be customer for other commercialization purposes. But especially what's happening in COVID and a lot of the tough times that a lot of people are facing. Bill, I want to thank you and K&L Gates for putting on this webinar for our members. Bill Simonitsch is on our board from SFMA. He's also a partner with K&L Gates law firm down in Miami, and they've got a global outreach. But I think this topic, 10 things manufacturers should know to prepare for customer bankruptcy, is really important. And this is really almost the start of something that the SFMA is creating in terms of a prepare, respond, recover, almost phased-in approach to helping our members get back to some normalcy during this COVID situation. So I'll touch on a few things at the end of the presentation. I don't want to steal much of Bill's time. Bill, the time is yours. Again, thank you for doing this morning.
Oh, my pleasure. So I'm going to be doing this webinar from the perspective of a manufacturer, which means two things. It's a manufacturer preparing for a customer's bankruptcy. So I'm not going to spend too much time talking about the different aspects of bankruptcy from a debtor perspective, when they're going to file, what they get out of filing, and that sort of thing. And it's going to focus a little more on issues concerning manufacturers and the sale of goods, even though oftentimes manufacturers are selling a combination of goods and some service. But there'll be some aspects that'll apply to both, right? But for those people that may be unaware that there are different types of bankruptcy in the commercial context, in the individual context as well, but I'm not going to focus on individual bankruptcies either, right? This is really business to business issues. So there's two types you would be concerned about in a business to business context. One is called Chapter 7, which is Chapter 7 under the Bankruptcy Code. The other is Chapter 11, right? 7 is a short conversation here because it's a liquidation bankruptcy. And basically what happens is a company files, a trustee takes over the company, and they're just shutting it down and selling all the assets. So you, as the vendor, as a supplier for that debtor, you'll get paid, if anything, pennies on a dollar based on whatever the sale of the assets of the company bring in, after you subtract out the cost of having to run the bankruptcy, paying the trustee, paying various expenses it costs to auction expenses, that sort of thing. So whatever the net remains gets divided up by the creditors. As an unsecured creditor, someone who sold goods without any sort of security interest attached to it, it could be even smaller because there could be, or likely would be, some sort of bank debt, some sort of secured creditor out there who has a lien on a number of assets. So as those things are being sold, your secured creditor eats up a lot of those assets.
And Bill, if I may, I'm sorry to interrupt you. I apologize about that. Two things I forgot to mention, housekeeping items. This is being recorded, so we'll send this out after the presentation. But also, for anybody who wants to ask questions, Caitlin Santonzi will be managing that for us. Simply use your chat feature, ask a question in that, and then at the end of Bill's presentation today, Caitlin will ask the questions to Bill that he can answer. Sorry about that, Bill. I forgot to mention.
Yeah, no problem. So last thing I would mention on Chapter 7 for this context is there are times when a liquidation will actually bring more value to the estate if it's sold as a going concern, a type of business where the trustee decides, you know what, I'm going to get more if I sell this as an operating company under the 7 rather than if I just chop up the parts and try and sell hard assets. So there could be a circumstance where you'll be approached to continue selling goods, or in some cases, goods and services, to that Chapter 7 debtor. And we'll talk a little bit when we talk about doing business with a company in bankruptcy. That'll apply both to the 7 and 11 context. So what is a Chapter 11? Well, this is a reorganization. It's an opportunity to give a company some breathing room to try and reorganize itself financially to return to profitability. There will be an automatic stay, which we'll talk about a little bit, which means that actions to try and collect the debt against that bankrupt company must stop. And if you continue to pursue, continue to try and take collection actions, continue to try and self-enforce in some way to collect on your debt, you could lose your claims and there could be sanctions against you for violating what they call the automatic stay. To be honest, the true reorganization Chapter 11 is a little uncommon these days. More often, they are ways where they say it's going to be a reorganization, but ultimately it's leading to a sale of the company or some other sort of event that could have been done in a 7, but there are certain benefits that I won't go into because, again, it's more debtor side issues to their doing a sale of the company through the 11 rather than the 7, right? But it can happen where there's a true attempt to reorganize the company. And this is important to keep in mind as we go a little further, and I'll sort of point it out, because when you make decisions as to whether or not you want to do business with the company after it goes into bankruptcy, that issue of, well, is this really heading towards a true reorganization, or is this really attempting just to sell it off later, can come into play. So that's the first thing you need to know, is that there's 2 different types of bankruptcies. And understanding what's happening is going to help guide you to make your decisions in terms of what you want to do to try and enforce your rights, both to collect and if you decide to go forward with doing business with them. The second thing is take a look at, if you're worried about a potential customer filing for bankruptcy, take a look at your contracts and purchase orders. And it may sound like common sense, but make sure you understand who the customer is under those agreements. Because in bankruptcy, the bankruptcy filing only applies to the entity that files. Oftentimes, you've got a company that has different affiliates, different subsidiaries. They may be using a fictional name, or maybe there's a general name that's being used that applies to multiple subsidiaries, and you just kind of consider it, hey, we're doing business with company X, but really company X that's their common name they're using, but as a corporate technicality, there should be a specific entity you're contracts with. So it's only the bankruptcy of that entity that's going to have the implications of the automatic stay and other issues that we'll talk about in terms of doing business with companies in bankruptcy. Similarly, you want to see if there's a guarantee, and that's going to play into, one, if the company files for bankruptcy, do you have the ability to go against the guarantor? It could be an individual, it could be a company, because again, that bankruptcy filing does not stop you from pursuing a guarantor. Or if you're thinking, well, I'm worried about this company, I don't know that they're going to be filing for bankruptcy, but I'm concerned because of the industry they're in and what's happening right now, or other impacts that you just know are going to affect them. You may want to say, well, look, we're a little uncomfortable. You could be going several more months having these financial obstacles because of the pandemic. We will sell to you now if you provide us with a guarantee, because that's going to give you that extra backstop to know, all right, if the company does file, we've got this other company, this other person that we can try to recover from. That doesn't mean that the guarantor can't file for bankruptcy too at some point, but oftentimes there are various reasons that a debtor will, that company will not want to. Like the individual may not want to be filing bankruptcy just to get out of that guarantee, though they could, because the other impacts bankruptcy would have on their life and their finances and their credit and other things they're looking to do. And similarly for a different company, a different subsidiary, they may have deliberate reasons for trying to avoid putting that entity in bankruptcy. For example, the assets of that company could be pretty valuable, and they don't want that to be filing bankruptcy, because then that makes it available for creditors when the company that filed for bankruptcy could be asset light, and they feel like that's a good shell to be putting into bankruptcy, because it's not going to be a whole lot of loss for them in the big picture. So second thing to know is take a look at your contracts and know who it is you're actually doing business with, and look for guarantors. The third tip: don't violate the automatic stay. So we touched on that briefly a couple minutes ago, where once the bankruptcy is filed, whether it's a 7 or 11, all collection actions have to stop. Typically what happens is once the bankruptcy is filed, a notice will go out to all the creditors that have been identified by the debtors, giving them notice of the bankruptcy and letting them know the automatic stay is in place. So you don't necessarily have to be constantly looking at bankruptcy dockets to try and figure out, well, how do I know if the customer's filed for bankruptcy or not? I don't want to violate the automatic stay. It's not that it's not that egregious where they're expecting you to know everything about every customer. However, if you were informed that a bankruptcy filing has been made before you receive the actual notice, well, then you are on constructive notice that bankruptcy's happened. So you have to stop any collection action at that point. You can't just say, well, I didn't get the piece of paper. Well, if you know, you know. You can't violate the stay. So you want to make sure that you immediately communicate the bankruptcy filing to whoever it is at your company that's responsible for billing and for invoicing. If you're engaging a collection agency for some reason, then you want to make sure that that company is aware, hey, don't take any further action with regard to company Y because they filed for bankruptcy. You'll want to take a look at, again, looking at your contracts, what were the pre-petition obligations, petition referring to the date the bankruptcy was filed. We call it a bankruptcy petition. So what are your obligations, or what was done pre-petition versus anything that would have to be done post-petition, right? And we're going to get into that a little bit in a couple items down here. But once you see that there's automatic stay, you want to say, okay, what can we stop doing as well, right? So if something is a pre-petition obligation, you may have to continue doing it. And if you refuse to do it, it could be violating the automatic stay because you're taking some action, particularly if you say, well, we're only going to do something if you pay us. But if something really doesn't have to be done until post-petition, that can come into play when we talk about different types of contracts and a couple items here. So the fourth item here is, well, if our customer files for bankruptcy and we haven't been paid for the goods, can we stop the shipment in transit? And the answer is yes, under certain circumstances. So you can stop the delivery in transit if you have not been paid for that shipment. You cannot do it punitively where you say, well, you paid for this shipment because for whatever reason, maybe because you knew they were in distress, you made them, pay in advance or in some form or a letter of credit or something. But you didn't pay us for our shipment last month. We're still waiting for that. So I'm going to stop this shipment you paid for because you didn't pay me for a different shipment. You can't do that. But if this is a shipment where maybe you sold it on terms and it's in transit, it's heading out of your facility, but it's on a truck, it's on a it's on a ship, wherever it is, you can communicate to the bailee, to the trucking company, to return the goods, to stop that shipment. Your right to, and it's called a reclamation. So your right to stop, well, I don't want to confuse you with the reclamation claim, so we'll just call it stoppage. All right, so your right to stop the goods in transit, your right to exercise a right of stoppage, ceases when the buyer has actually received the goods. They've got physical possession of it. That can be, it got to their warehouse. It could be, if it's a drop shipment, it got to their, to their customer. It could be they have their own truck and they came and picked it up. So if it's their own truck, they've got possession of it. That's different than if it is a third-party trucking company that's come to pick it up and deliver it to them. Even though they may have been the one to arrange the trucking, it is not in their possession. And then you can contact the trucking company and say, look, we need this returned to us. And this is based on insolvency, not necessarily bankruptcy. Insolvency is an evaluation based on, do the liabilities exceed the assets of the company? You may not always know that, so it's a little hard to determine at times. However, in order to file for bankruptcy, they have to state that they're doing so because their liabilities exceed their assets. So the filing of a bankruptcy in itself is sufficient to establish that you have a right to stop the shipment based on insolvency. It's trickier if you're trying to do it and they haven't filed. You just hear, hey, they're under financial distress, they defaulted on some note or loan. It gets a little risky because you don't really have an insight into their finances. there can be some complications that come up depending on the bills of lading or warehouse receipts and the negotiability of those as to whether or not you can stop the shipment, right? Title isn't definitive. They can technically have title. For example, it could be, an ex-warehouse shipment. They've got title, but it's in transit. You can stop it so long as you haven't been paid. But it's given the amount of time we have here today, it's a little outside the scope to really dig into some details of some of the shipping documents that can affect title. So anytime that you're really looking to exercise this right of stoppage, which, the debtor could really depend on that shipment. So it could be a hard-fought issue. You may want to get legal counsel taking a look at exactly what the illegal arrangement was and what documents are being provided with regards to that shipment to ensure that you can do so. We talked earlier about the automatic stay. The courts have determined that exercising your right of stoppage after the debtor has filed for bankruptcy does not violate the automatic stay. However, if it was determined that because of some of the technicalities of the instruments used to transfer the goods, you could have some issue where, well, you exercise outside of your right of stoppage, and therefore we're going to claim it's an automatic stay just to mess with you and get leverage over you. So you want to be a little careful and get some guidance and legal counsel before you do it. So point number 5, if our customer files for bankruptcy and we haven't been paid for our delivered goods, can we get them back? Right. So this is different than the last scenario, because the last scenario, delivery was in transit. This one is, well, they've got physical possession, so we can't use our right under the commercial code to stop the shipment. Can we just get it back? We have been paid, it's in their possession, but we just want to get it back. There is a right called reclamation under the bankruptcy code. In order to exercise that reclamation and get the goods back, the goods need to have been sold in the ordinary course of business. That's a term that comes up a lot in bankruptcy, the ordinary course of business. In other words, your sale of these goods is what you ordinarily do. This is in your line of work, and you're shipping something that is not an unusual amount or volume given your company and the debtor's company. And it's the ordinary course of what the debtor does, right? In terms of what their business is. To exercise your right of reclamation, the customer also has had to receive the goods, taken physical possession of the goods, while insolvent again, within 45 days of its filing the bankruptcy petition. So there's your window. If you shipped it to them 50 days before they file for bankruptcy, you can't demand reclamation. 45 days, you can. Now, again, there's this question of solvency, right? They have to be insolvent. In most cases, by the time a company is actually filed for bankruptcy, it will have been insolvent for a significant period of time before that. That can depend on certain unique circumstances, right? Say a company could have been solvent, then they lose a big court case, suddenly they have a judgment for $5 million against them. Suddenly they're not solvent anymore. And they go ahead and file for bankruptcy to try and deal with that judgment. That could be a circumstance where less than 45 days out, they were solvent and just suddenly became insolvent. That's an unusual circumstance. You would likely know about that, because if you're paying attention to your customers and what's happening to them, you'll be aware of something significant like that happening to them. In most cases, it's been a slow decline down the road of insolvency, and that 45-day window is really not an issue. Another factor as to whether you can get those goods back is whether there's a secured creditor out there, such as a bank that has what's called a floating lien. In other words, a lien on inventory or otherwise on all assets of that company, of that debtor. So what you'll have to do is take a look at the state of Florida. If you're in Florida, or other states have them too, will have online databases you can access to look for UCC liens, UCC Uniform Commercial Code liens. So you may be aware of it if you've got even a mortgage or some secured debt your company has. Well, these liens, these mortgages, any sort of security interest will be recorded if it's on personal property, like inventory with the state. If it was on real property, well, then it's going to be, in the local county. So if you see, all right, well, this company's got this huge loan out with Wells Fargo, and you look and you see on the lien, as Wells Fargo says, this lien is on all inventory, all assets of the debtor. Well, once they have it, it's their inventory. It's the customer's inventory, and you can no longer reclaim it back because it's the collateral of the lender, right? The goods also have to still be in their possession. So it could be within 45 days, there's no floating lien, but they've already shipped it off to somebody else. They've already sold it to somebody else. You can't go down the line and say, well, look, we were never paid, so third party, you need to return this to us. It doesn't work like that. Once it leaves your customer's possession, you can't reclaim it back. And then finally, there is a notice process. You have to make your demand for reclamation in writing. That has to be done not later than 45 days after the date the customer gets the goods, or not later than 20 days after the bankruptcy starts if that 45-day deadline falls past the commencement date of the bankruptcy. So there are time frames to pay attention to as well. And if the notice of bankruptcy gets to you or your company, and it gets stuck in a pile of mail that you're not going to look at for a while, you could end up blowing your deadline if 21 days after the filing you realize, oh wait, I didn't realize the company filed for bankruptcy. I want to try and reclaim and get those goods back. Too late. It's too late to do the written notice. You can't exercise it. So number 6. Okay, in this scenario, your customers receive the goods. You can't demand reclamation for whatever reason. It could be because there's this floating lien of a lender or deadline is passed. How do we get paid then? Well, if the debtor received the goods within 20 days before the bankruptcy case, you will have an administrative claim in the case. So to understand that, we need to back up a second and understand that in bankruptcy cases, there is a priority as to who gets paid when, right? And in these commercial cases, you're going to look at, well, there's, the trustee, the trustee who, if there's a trustee in place running the company as opposed to the debtor running it itself in bankruptcy, those costs get paid first. Anything related to the administration. Then you have what's called administrative claims that are often those companies that have decided to go ahead and do business with that bankruptcy debtor after the fact, but they want to get ahead of line of everybody else to give them incentive to sell. And likewise, if you sold those goods within the 20 days of the case, you will also get the administrative priority. So that puts you ahead of every other unsecured creditor, even to some extent yourself, for shipments you may have provided outside that 20-day period. So if you sold those goods 45 days, well, we'll say 50 days before the bankruptcy, you have what's considered a general unsecured claim. That is pretty far down the line of priority. There's only a couple of folks that will have any lower priority than you. We don't need to get into that right now. But unsecured creditors are getting pennies on the dollar out of whatever little amounts are left over when they're determining how creditors are going to get paid in a case. You're a lot better off with a higher priority. There's different levels of unsecured creditors, and certainly having an admin claim is about as good as you can get without being a secured creditor itself. Because of course the secured creditors argue, look, it's our collateral. And other than the trustee, secured creditors are king. So administrative claims get paid with priority, which means they'll likely get more money. They're more likely to get paid at all out of the bankruptcy case and the reorganization. It's not foolproof because it's always possible that the case can't survive bankruptcy. It's going to go from the 11 and say, you know what, this just won't work. We're just going to shut it down and liquidate, turn into a 7, and then maybe there's not even enough for the admin claims. So it's not a guarantee of payment of 100%. So don't get too excited and say, oh, well, it's admin, it's within 20 days, we're going to get all our money eventually. The eventually could be a long time, and it really depends on how much money ends up getting made available for creditors in general through the reorganization plan. In order to have this admin claim for those goods, it also has to be, again, sold to the debtor in the ordinary course, not some sort of weird sale of something that has nothing really to do with what the debtor does for business. You know, say the CEO of the company suddenly decided that it was going to order through the company, I don't know, shipments of stuff that was really for himself, you know, a bunch of clothes, personal computers, I don't know, decides to get into Bitcoin, and it has nothing to do with the ordinary course of the debtor, you may not get that admin claim because it really wasn't for the benefit of the company in their ordinary course of what that debtor does. You don't automatically get the admin expense treatment. If you sold these goods within 20 days, you're going to have to get an attorney to move the bankruptcy court to award that to you, to grant that. Again, it is the second highest priority in these commercial cases. So if you're owed a significant amount of money, it's worth doing. But again, there's also court-ordered deadlines. The court itself at the beginning of the case will put out a deadline. It's not in the code. You won't know till the case is filed of when that claim, it's called a 503B9 claim, when that has to be made. And if you blow the deadline, you write the claim for administrative expense, and you're going to be stuck with the rest of the unsecured creditors hoping to get pennies on the dollar. As intimated before, if you cannot make that admin claim motion because you blew a deadline or wasn't within 20 days, you get a simple proof of claim. These can be done by your company itself. You don't have to hire an attorney for it. Some do. It really depends on what kind of experience the company has dealing with these types of claims. It's a form, so you're not really creating something. If you go online and you type in, you know, Southern District of Florida, assuming it was filed in the Southern District of Florida, which covers, you know, the Tri-County area, type in proof of claim, you can see the form. It gets a little tricky where there's three aspects, and I don't want to spend too much time on it, but there's three aspects of the proof of claim and determining what the amount is, and that is whether or not the claim is contingent, unliquidated, or disputed. And just to give you a sense of what that means is you could have a real simple claim. We sold them 1,000 widgets. The purchase order says that they pay us X amount for those widgets. They receive them. They haven't said there's any defect with them. There's any problem with them. They just owe us the money. That's very simple. And you put in the price into proof of claim amount. This is how much it's owed to us. There may be other things you think you're owed, though, right? So it could be a contingent claim where you're saying, well, you know what? Something has to happen first, and then we're owed the money. It hasn't happened yet. So I can't say they owe me right now. But if that event occurs, they may have to. So let's say that you were providing goods as a materialman to a construction project, and that contract has a pay when paid provision, right? And say it was your contractor that filed for bankruptcy. Well, they don't owe you the money for the goods yet, unless they've been paid by the owner. But once they get paid by the owner, you are entitled to it then. So your proof of claim, you would list under, you know, as a contingent claim, that amount that you should be owed when that event occurs. The proof of claim form is also going to ask you, is there an unliquidated amount that's owed to you? Unliquidated simply means it's not calculated, right? It may be it's not quite yet determined, right? Say, you know, it's a little out of context, but say a personal injury claim where it's like, well, look, somebody got hurt, or maybe it's a product defect. Somebody's claiming that, you know, or we are claiming that some sort of, you know, something has occurred regarding this sale, this product. We're going to be owed money, but until some forensic expert comes in and runs some calculations and some theories, we don't really know what that amount is. Our best guess is X. Our reasonable guess is X, but it's really not yet determined. That's considered an unliquidated claim. And you can add that to your claim, even though it's not yet liquidated. You just won't be paid on it until during the course of the bankruptcy case, somebody comes up with a liquidated figure. Oftentimes, the reality is this is just negotiated out between the parties because neither you nor the bankruptcy debtor or the trustee really wants to spend money on an expert to crunch those numbers. Most often it's just a matter of negotiating some dollar figure. And then finally, there's going to be the disputed amount, where you're going to say, hey, I'm owed, $50,000 because I sold these widgets to the company. But you already know, because you've had communications before the bankruptcy, that customer is saying, I don't owe you that money. Maybe the goods were non-conforming or in some way, or were defective in some way, and we're not paying you for that. Well, you certainly think that you're entitled to it, but you already know it's disputed. And that's something else that will then have to get fleshed out. You can make your claim. If you don't make it, you'll waive it, right? And that's an important thing to note here. All these things, your contingent claims, your unliquidated, your disputed, if you don't claim it in your proof of claim, you'll waive it. So you don't get to say later and go, wait, I know you paid me for this stuff that's real straightforward, but I'm still owed some additional money. Doesn't matter. So you always make the claim, understanding, however, that it's going to have to get worked out and fleshed out through the bankruptcy case itself. And again, with these disputed claims, most of the times they're negotiated out because nobody wants to spend the money really going to battle over it unless you're talking about a really sizable amount of money. So item 7. So we sell to a customer through purchase orders only. If the customer is in bankruptcy and wants to keep buying from us, should we do business with it, and how do we get paid? All right, so the idea here is you've got a purchase order. I say purchase order only in this scenario because I'm not talking about those scenarios where you have a long-term contract, some sort of long-term sales agreement, and then purchase orders come in from time to time under that contract. We're actually going to go through that scenario next. This is one where these are all just one-off shipments. Purchase order comes in. The only terms between the party are in that purchase order. And if another purchase order never comes in, you just never are doing business with them. And if more come in, then you'll do it on a case-by-case basis, and you're always free to try and change the terms of the purchase order as your relationship progresses. Well, in that scenario, if you've sold the goods under these separate purchase orders, then you can decide if you want or do not want to do business with that debtor after it files for bankruptcy. Now, remember that I mentioned before, if you do business with the debtor after it's filed for bankruptcy, all these new shipments, these new goods you provide, well, for one, they're going to be given an administrative claim, which may or may not give you a whole lot of comfort based on what my comments were about administrative claims before. However, there is an expectation and, in fact, a requirement that the debtors during the bankruptcy are current on all post-petition obligations. So in order to stay in bankruptcy, in order to get the reorganization relief that it's looking for, it has to pay its debts when they come due during the bankruptcy. If they don't, the view of the courts is like, well, you're sort of establishing that even with this relief, even with not having to pay all these old debt, you're not even capable of paying current debt. Well, they're going to say, well, you're going to have to convert this and just liquidate the company. Now, it's not going to help you again. You don't want your pennies on the dollars if they liquidate. But the point is, they will try very, very hard and to pay you currently and to even enter into some of these contracts to when the trustee or the debtor says, on a regular basis to the court, this is the status of the case, this is what we're doing business on. They actually provide reports to the courts of, here's all the expenses, here's how we paid, here's how we're current. We're not in default of any of these new obligations. So you actually are in a pretty secure position selling goods to the debtor after they file for their bankruptcy, except for, as I said, that risk that if it cannot successfully reorganize and it has to liquidate and gets converted to a 7, well, then it's like any other 7, and it's just going to sell it all, and whatever amounts are left after the sale are going to go to creditors. So you do have an ability to get some extra assurances, however, depending on what it is you're providing, right? So if you're selling, $1,000 worth of widgets post-bankruptcy, and it's not a huge deal to you or the debtor, frankly, or they can get it someplace else, you're not able to negotiate much in terms of any sort of friendly to you term to give you some sort of protection to feel like, hey, I'm not going too far out of here and running a risk that if they convert, I'm out the door. Then the courts can say, well, you're out the door $1,000. Why are you wasting my time? If, however, this is a sizable deal where it's like, look, gee, they want to buy, $1 million worth of my goods. They're in bankruptcy. Here's what they're saying they're going to do with it. But gosh, if they get converted, I'm out. I'm stuck on this. Well, no. Who would want to do that unless you can get some extra assurances, right? So, going through the court through a bankruptcy lawyer, and I mentioned bankruptcy lawyer because in bankruptcy court, you cannot, as a company, represent yourself. You can't be pro se like an individual can. So you're going to have to get a lawyer to do this. You can get some provisions where, hey, this is how payments are going to be made in some way, so I'm not extending out too far. Here's some assurances I'm going to get. Here's some guarantees I'm going to get. It's all very negotiated. Bankruptcy is a very negotiation-heavy process, right? Everybody wants to just work out a deal and not really have to fight in court if they can avoid it. So there can be ways to give you some comfort beyond just administrative expense, beyond just the general obligation to get paid timely, to ensure that if you're going to be incurring significant expense in order to provide these goods to the debtor, that you're not going to be left holding too much if they were to have to convert to a Chapter 7. In order to do that, however, the debtor will cooperate with you because they want the goods. They're going to have to show the court that, look, this is really necessary. The value of these goods that are being sold is reasonable. It's not some inflated amount that they're trying to get some sort of cushion deal, maybe to make you happy for other reasons, maybe relationship with the company or something. No, it's a reasonable amount. It's necessary to the company. And then the court will authorize and bless through a court order whatever special negotiations you make to give your company comfort that it can go out on a limb and provide these goods. You have to keep in mind, though, that when you get paid post-petition, again, that means after the bankruptcy started, when you get paid post-petition for goods you sold post-petition, you can only apply those payments to the post-petition debt. It can't go to pay pre-petition debt. Now, number 8, we sell to a customer through a long-term agreement. If it files for bankruptcy, must we both keep performing under the agreement? And how do we get paid? Right. So the term for this is an executory contract. Right. This is this long overarching contract where there's a number of different obligations on both sides. Sometimes it's just the obligation to sell and the obligation of the other party to pay. But maybe it could be a long time period. It could be you agree, under this contract, you're going to provide all the glass jars that the customer is going to need over a 3-year period at X price for X volume, that sort of thing, right? Executory contract. And even if you are then selling on a purchase order basis for logistical reasons, the POs don't stand alone. They're just a tool for the ordering of goods under the longer term executory contract. In that circumstance, when the customer files for bankruptcy, you cannot simply stop performing. You can't say, well, they filed for bankruptcy. I don't think I'm going to get paid, so I'm just going to stop performing. You can't do that. That's a breach of contract. And the customer will have a right to come after your company for damages, just like any other company that is suffering from a breach of contract. In the bankruptcy context, it is actually the debtor who gets to decide, am I going to assume the contract, mean keep it in place, or am I going to reject the contract? There are deadlines within the code on when it's supposed to accept or reject, or sometimes it's modified by court order. But I can tell you frequently it's extended over a long period of time where you may have to perform not knowing if they're ultimately going to accept or reject this contract. The good news is you're not doing it for free, okay? So even though you're performing while the debtor's still thinking about what they have to do, the court has to have them current in their payments for the post-petition obligations. So just like we talked about before, in the other context, if it's going to say we're going to keep this contract in place until we, the debtor, decide if we're going to terminate it or assume it, it has to pay currently for everything that you sell or do under that contract after the bankruptcy petition was filed, right? If they decide to assume the contract, right? And I'll tell you that some of the analysis the debtor is going to do when they're trying to determine do we assume or reject is trying to renegotiate terms with you. Well, we could assume this, but gee, we think we could reject it and get a better deal from someplace else. They're hoping that you're going to say, well, all right, well, I'll negotiate some sort of better, more favorable terms in order for you to keep us as your supplier, if that's in fact what you want, right? And oftentimes this could be a pretty important customer for you, so perhaps that is exactly what you want. Well, if the debtor assumes the contract, well, it has to then pay, in bankruptcy terms, cure any payment defaults and show that it can perform in the future too. So in other words, this is a nice deal. If you've got this executory contract and they have pre-petition obligations to you, to assume that contract, it has to pay you for all the past due amounts and show to the court when they say, court, we're going to assume this, here's how we have the budget based on our projection going forward in order to be able to pay this, so that it's not they're assuming it and then 3 months later they're in default because they can't pay you. The same thing happens if someone's going to try and buy the assets of the company and try and get an assignment of that contract. Before it can be assigned over to a third party as part of some reorganization plan, you have to be made whole, or else they cannot assume the contract. If they reject the contract, well, you still have a claim for damages. So the fact that you may be out, just like any other situation where a customer breaches the contract with you, you could have damages. You could be, well, look, we have this contract to fully supply you with all glass jars you're going to need. The projection was X amount based on your representations. We had to hire this many more people. We had to bring this much more equipment. Here's all the things we've done. We have all this back inventory now that we're ready to ship out. You're rejecting this contract. We're out here. We're damaged by this, just like you would be if they terminated without them being in bankruptcy. You can have a claim for damages. The two problems, unfortunately, are one is you're going to have to, just like in any other circumstance, either litigate or negotiate what those damages amounts will be. And then second, it becomes just a general unsecured claim. So now you're in that pile of creditors, the unsecured creditors, who again, they're going to get pennies on the dollar. So it's not a great place to be rejected, unless, of course, for whatever reasons, you realize, you know what, we'd rather get rejected because then we can focus our efforts elsewhere, where perhaps it would be more profitable because maybe you had a lousy contract, with that particular customer in the first place. So it could have a silver lining. It could be pretty miserable. It's going to depend on your individual circumstances. So 9, the customer is in bankruptcy and claims that they'll be paid as a critical vendor if we keep selling to them. Well, what does that mean? Okay. Well, remember we talked earlier about you may have, if you don't have this long-term contract, the ability to simply decide a customer in bankruptcy is too much of a headache. We just do deals on a purchase order basis. I'm not interested in doing this anymore. But what you provide could be crucial to the debtor's operations. It could be you're one of the few people that can provide it, or the few people that can provide it on the cost basis that you do. And the view of the debtor is, we can't actually successfully come out of bankruptcy. We can't put together a plan. We can't become profitable if this manufacturer stops doing business with us. So they're going to go to the bankruptcy court and goes, we want this manufacturer to be treated as a critical vendor. The benefit of that is that the pre-bankruptcy debt can get paid in order to incentivize you to do post-petition business. All right, so we talked a little bit earlier about, you can choose to do the work post-petition, but you're gonna only apply the money you receive for the post-petition goods, the post-petition debt. You can't pay off the pre-petition debt because that's just a general unsecured claim. If you're a critical vendor, you can get paid. So the incentive is, hey, look, you're going to get paid current for anything you do post-petition, and to further incentivize you, we're going to pay you for what we owe you pre-petition. That way, you don't have to worry as much about getting pennies on the dollar. Depending on how critical you are and depending on what all the different moving parts of the bankruptcy, it could be we'll give you an admin claim priority for your pre-petition debt. But if you're critical enough, it could be, the debtor says, Your Honor, we need to actually pay them and pay them now, and we have the resources to do it, or else this bankruptcy fails. You can't seek this yourself. You can't decide for yourself that you're a critical vendor, even if you legitimately think you are. The debtor has to be the one to seek this from the court, and the court has to bless it. And a lot of people are going to be critical of it, right? Because you're jumping ahead and getting paid, and the lender is going to look at this and say, wait, I'm the lender. I've got collateral. Maybe it's my cash collateral, right? If the bank's got a lien on cash and receivables, then through the bankruptcy court, they need to get permission to use the bank's cash. So they may say, why is this really critical? And why do you need to use my collateral to do it? There may be a creditors committee, an official group of other creditors that are put together to sort of represent the creditor body as a whole. And they could say, I don't think these guys are really critical. I think that, the president of the debtor is a golf buddies with the president of the manufacturer, and he's just trying to hook them up and get them paid for some of the pre-petition debt. This isn't really critical. So the debtor may have to show some of those things that I talked about a minute ago, which is, look, limited sources for these goods, or exceptional pricing available from this manufacturer is going to limit it, or manufacture time is shorter. We need these products by X. Everybody else needs much longer lead time than this manufacturer. So this manufacturer, we can get it within a week instead of a month. So then maybe that lead time will play into the critical vendor aspect too. Finally, number 10. So we performed our obligations. It's without flaw. There's no claims that there's any defect or nonconformity with the goods that we provided, and we've been paid. So we're good. We don't even have a claim. We're 100%. I can look at this, bankruptcy notice and go, well, I don't care. I'm not owed any money, and I just don't have to do anything with them anymore if I don't feel like it. So I'm going to move along. I don't have an executor contract. I'm going to go on with our lives. Can the debtor or the trustee running the debtor force us to return any of the money that we got? It can, under certain circumstances. So the debtor can make what's called a preference claim for any payments that were made within 90 days of the bankruptcy filing. Now, I'll tell you, there's supposed to be an idea that, well, look, what is the definition of a preference under the code? Well, that is, it's a payment on an antecedent debt, meaning an old debt, not a current post-petition debt, right? It's a payment that was made to you while the debtor was insolvent. We talked about when they are insolvent or not insolvent. Again, it's an asset less than liability analysis. To a non-insider creditor within 90 days of the filing of the bankruptcy. The reason non-insider is relevant because if it's actually an insider to the debtor, like the owner of the company made a loan to the company and the company pays the owner, there's actually a longer period of time to recapture and claw back payments. And then the last aspect is that it allowed the creditor to receive more on its claim than it would have if the payment had not been made and was paid through the bankruptcy. In other words, they're going to say, well, look, you got paid 100% for these invoices that were due within 90 days of the bankruptcy case. If you were paid through the bankruptcy, you get pennies on the dollar. So you are ultimately being treated more favorably as a creditor than other creditors. And that could be true for whatever reason. It could be that you were paid 100%, but a whole bunch of other creditors didn't get paid for 120 days after that. They just chose, we're going to pay you guys, but not these other guys. So there is an analysis to be done as to whether or not the debtor can claw back anything paid within that 90 days. And then you just have to file a proof of claim for the amount that is owed you as if you had never been paid during those 90 days. Here's the problem for creditors. The trustee or the debtor is supposed to do an analysis where they sit back and go, really, what are we looking at, right? Is this really a preferential treatment, or is it payment in the ordinary course, right? So there's 3 defenses to these preference claims. Are you being paid in the ordinary course, as in this debtor has always paid you very timely, invoices issued, you're paid within 30 days. It's a payment on a current invoice. It's within, the time period they always paid. It's not that, hey, within 90 days of the bankruptcy, he paid you for aged receivables that were 6 months old, and suddenly you're getting paid it, nobody else is. This is, hey, he's always been current. Even if he wasn't current with everybody else, he's been current with us. Is for a current invoice, ordinary course defense. Or it's a new value meaning, well, the payment was made, but we agree that, hey, you pay us X amount, pay us $10,000 worth of this invoice, and we'll agree to go ahead and ship you an additional $10,000 worth of goods. Well, that can be new value or contemporaneous exchange, just depending on how it does, which is, another defense, which is, agreeing to offset amounts owed in exchange, or provide goods in connection with current payments. So the idea is, did you give any value? Whether it be contemporaneous or not, the idea is, well, did you just get paid within 90 days, or did you actually either were paid in ordinary course or gave something to the debtor to which the debtor received value because it paid you outside the ordinary course, right? So the idea is they got something out of it that justifies me keeping the money. So before a trustee or a debtor goes after you, you're after your company, they should do that analysis so they're not sending out frivolous notices to companies that, hey, we have a preference claim, return the money. Because that's what happens. The notice will go out, you'll receive it from the trustee or the debtor that will say, hey, you received a preferential payment within 90 days of the filing, return the money, or we will initiate a lawsuit against you through the bankruptcy case to sue you for that money. The problem for creditors are the trustees, not to cast dispersions against all of them, but I haven't seen one that didn't do it yet, don't do the analysis. They look at who got money within 90 days of the bankruptcy. Everybody gets a preference notice. And then it's on you to try and fight back against it being a preference, right? And oftentimes that involves hiring an attorney who's going to say, look, here's the proof that this is ordinary course. Here's the payment history for the last year. It's ordinary course. Here's the agreement where they said, okay, we'll pay, this 6-month-old debt if you're going to ship us some new goods, right? They put the onus on you, the creditor, which then gives you the expense to deal with it. What they're hoping for is you don't want to spend the money, because they're always willing to negotiate. Or you're going to say, look, this is the scenario. We don't think we should have to return it. Trustee's going to say, well, you could hire a lawyer and you can pay that lawyer $10,000, $20,000 to try and fight over your $50,000. Or how about we just work out a deal? You give me 30, you keep 20, we'll consider it settled. And that's how they build up bringing money into the estate. Because it's not just, as they build up the amount to pay creditors, it's not just assets, it's not just ongoing revenue of the business, it's what can they claw back from everybody they paid, even if they paid them for legitimate reasons. So yes, preference actions are a real thing, and you got a lot of creditors out here who feel they get really treated very unfairly, where they got to return money they owed. Again, you do get to file the proof of claim to get that money back later, but it's going to be pennies on the dollar. So at that, it is 10:29. So Caitlin, we have time for maybe one or two questions to stay within our 1 hour time limit.
Sure, and I actually have 2 questions, so I'll go ahead and read those out. First one is, what should a business do quickly when they first get hints that a customer may go bankrupt?
You're going to want to take a look at your agreements. Make sure, as we said earlier, make sure you got the right entity. You want to look at what is in the pipeline, right? Are there shipments about to head out the door that maybe you're going to want to stop? But you're going to want to make sure you are operating, whether you're operating under the executory contract or a purchase order, because if you take, if they haven't quite followed yet, you could be brought in as for taking sort of action against somebody because there's an intent to file bankruptcy, and you can't prejudice a company in a way that, by breaching your own contractual obligation because you're worried about them filing for bankruptcy. However, the reality is it's a cost-benefit analysis, right? If you're looking at, well, let's see, I think these guys are going to be filing for bankruptcy. I'm supposed to ship these goods out, but I haven't been paid for yet. I could be considered in breach of the contract if I don't, but is it better for me as a cost-benefit analysis to have my stuff that I can then sell to somebody else? And if the debtor decides later, or the trustee wants to come and give me a hard time and say, well, this was an executory contract, you should have performed it, I can deal with that then. I can negotiate, all right, I can provide it now, we're going to work something out. But it may be at times you can say, you know what, it's worth the risk because I'm not sending $1 million of product out the door just to have that claim against me. I'd rather not be out the money. If they want to say, well, I owe them the widgets or something, I'll deal with that fight later. Ultimately, if that fight comes, you're going to want to retain counsel. You may want to have one look at your documents ahead of time. If you're talking about a big amount of money, again, if it's not huge and it's like, well, look, it's $10,000 worth of goods, it's not worth me hiring a lawyer. We'll just do the minimum then, at least looking at it and saying, you know what, I think it's worth, that we just hold it back, and we'll find a reason to hold it back, and let them deal with it later. Again, not every bit of advice is going to, I hate blanket answers because I don't know your specific scenario, but that can be a way to look at it. You have the technically, what must we absolutely do versus sometimes to do business, you're evaluating your risks, and sometimes it's worth the risk of not shipping to somebody who thinks about the file.
Okay, thank you, Bill. And the final question is, does a trustee in a 7 or 11 restructure get an asset valuation on machinery and equipment of the bankrupt entity to validate the value of that equipment at an auction, or is that the secured party's responsibility?
The debtor should be getting their independent appraisal, where they're going to go and they'll be talking to the court and saying, well, we're going to auction these. We're expecting X amount. They can, depending on the case, actually say, well, this is this professional auction company. They have appraised at X amount, and we're going to seek permission from the court to sell these assets in that range, and to ultimately, when we sell it, any sale is going to have to get blessed by the court. So what'll happen is they'll auction it. It'll be contingent. The sale will be contingent on approval from the bankruptcy court. They'll come back and say, court, this is how it went down. This is the procedures that were followed. These are proper procedures. Here's what was the appraised expectation by the auctioneer. This is what we received. This is why it varies either up or down from that amount. If the secured creditor feels that it is far less than what should have been received, it does have the ability to object to the court's approval of the sale, whether it be based on the procedures and marketing of the assets being insufficient or simply being below market. What can happen if you're a secured creditor and if a lender, the court could say, well, I'm a little on the fence here, but if you really think it's worth that much more, well, then why don't you, as a secured creditor, why don't we just agree that you'll get that asset? You have to pay what you're saying is the amount that should be going to it, and then you go ahead and sell it. And if you can get more for it, knock yourself out. So I mean, that's essentially the answer. It's on the debtor to lay out all that entire process, including getting appraisal to get court approval of a sale. But if you're a secured creditor and you disapprove it, you can get your own appraisal and fight it.
All right. Thank you, Bill. Those were the only 2 questions that came in through the chat.
Okay,
And
great. Thank you very much.
Bill, thank you very much for taking the time this morning to do this for our members. I know it was very informative, very helpful, and hope a lot of the folks on the call today or the webinar today got a lot out of it. For those that want to maybe chat with Bill offline or need to reach out to him for any reason, please email me or Caitlin Santonzi. We'll get you connected directly to Bill. His firm, K&L Gates, is a great corporate partner of ours, has been with us for 2 years now and has provided a lot of value. So Bill, we really appreciate you doing this for us. As I mentioned earlier, this is recorded. We'll most likely send this out on Tuesday. Caitlin every week is preparing a SFMA informational item of the week type of newsletter, if you want to call it, but we'll include a recap of this webinar and the link to the recording for all of our members. So actually, I think someone else has a question.
No, that was me responding to
gotcha.
that
Okay.
question about Tampa.
Got it.
Now, just answering that, I do practice in bankruptcy court in the Tampa area. I don't belong to the Voluntary Bar Association there, but you don't have to. I'm admitted to, southern, middle, and northern districts of Florida, so I can do bankruptcy anywhere in the state.
Perfect. And then tomorrow, SMA is putting on another webinar, guidelines on how to operate during this normalcy, the new normalcy during COVID-19. We had a group of manufacturers that were charged along with SFMA from the mayor of Miami-Dade County to develop some guidelines on how to either reopen or if you have been operational, how to keep your employees safe. We developed some guidelines that were blessed by the mayor and actually some doctors from 2 of the hospital systems down in Miami. So we're going to have some of those manufacturers on the webinar tomorrow talking about their interpretation, application, best practices of some of the guidelines that were created that we'll share tomorrow. So if anybody has not registered for that webinar, please go to our website, sfma.org, and then in the networking piece, you'll see events and drop-down box. So feel free to register for that. It should be very informative and very valuable. Again, thank you everyone for your time. Bill, again, thank you for your time today and your expertise, and we wish you all a good day.
My pleasure. Good day, everybody.
Thank you.